Yes, claimant to report, my lord.
Okay. Defendant absent.
Yes, my lord.
Appearances.
May you please this honorable court. I am.
Yes. Go ahead.
May you please this honorable court. I am CN Minister Claimant.
Sorry?
I am CN.
Your name is who?
CN.
Please spell your name.
Make sure we say UN. I.
Put the name in the chat box, please. CN Umesiobu. You are for the claimant. Any other appearance?
No, my lord.
Any other appearance?
No, my lord.
There is one Chibueze Yadabua. Uche and Warren, are you in this case? For a different case.
Yes, your lordship.
Please unmute.
It's a different case.
For a different case.
Yes, the second case, your lordship.
Okay. So kneel for the claim for the defendant. No appearance for the defendant. Court registrar.
Yes, my lord.
Very well. I'll go ahead and deliver the judgment because the defendant was in court when the case was adjourned.
As court pleases.
Let me have the file. Court registrar Lokoja and DL, did you inform the parties, Mr. Umesiobi? How did you get to know of today's date?
My lord, the counsel to the claimant is unfortunately late. Mr. The counsel to the claimant is unfortunately late. Yes. And I happen to be a lawyer in his law firm.
I can't hear you. How did you get to know about today's date? I'm a
lawyer in his law firm.
Okay, and he said that the matter is coming up today.
For judgment, yes, my lord.
You don't know how he got to know. Okay, in any case, Go ahead.
I'm a lawyer in his law firm.
I've heard you. So how did you not get to know? He just told you that this matter is coming up today and that you should go?
My boss informed me of today's date.
So he must have been informed by the court. The court must have informed him. And I believe they will do the same to the defense counsel. So the judgment is ready. I'll go ahead and deliver it. Here is the judgment of the court.
As the court pleases.
By general form of complaint filed by the claimant dated 11 July 2019 and filed on 5th September 2019, praying the court for the following reliefs. A declaration that the non-payment of the claimant's salaries and entitlements by the defendant since the month of September 2018, except February 2019, is illegal, unlawful, abusive, and humiliating. 2, another of mandatory injunction compelling the defendant to pay the claimant his salaries and entitlements owed him since the month of September 2018, except February 2019. C, an order restraining the defendant either by themselves, servants, agents, previous officers, authorities, bodies, or any other persons, howsoever described, from interfering, disturbing, or howsoever tampering with the claimant's appointment until the backlog of his salaries and entitlement being owed him since September 2018, except February 2019, is paid to him. D, a declaration by this honorable court that failure of the defendant to pay the claimant his salaries and entitlements since September 2018, except February 2019, have caused the claimant a lot of suffering, hardship, and humiliation. E, general damages in the sum of 150 million naira. And F, legal professional fees in the sum of 1 million naira. It is the claimant's case that he was employed by the defendant in 2003, left the service of the defendant in 2015, and was asked to return in September 2015. He averred that he carried out in any way whatsoever by the defendant since 2003 before his employment was terminated on 10th of May 2019. He averred also that after his employment was terminated on 13th May 2019, and when he went to the office in line with the directive and the letter of termination to finalize the release of his salaries and entitlements, he was told that he would not be paid. And upon this, he made several frantic efforts to find out why the defendant had refused to pay his salaries or entitlement, but was turned down. That failure and refusal of the defendant to pay him has caused him and his family members their health and financial challenges. He averred that he hasn't been paid since September 2018, except for the month of February 2019, which led him to hire the service of a lawyer, hence this action. Although the defendant entered appearance in this case by way of physical appearance made by learned counsel for the defendant, 1BM Musa of counsel, on the 18th of March 2020, he informed the court that the defendant is in the process of filing its defense to this suit. On the 9th December 2021, when the claimant opened his case, defendant counsel Inobaraye Esquire appeared for the defendant. He participated in the trial and said he has no questions for the claimant's witness. It is on record that the defendant has since then failed to file any processes in this suit. It is only the claimant who filed his pleadings and testified in this case. On the 9th of December 2021, the claimant opened his case and testified for himself as CW by adopting his written statement on oath made on the 5th of September 2019 as his oral evidence in this case. The documents intended were admitted in evidence and marked as Exhibit M to M3 without objection from learned counsel on behalf of the defendant, Inobaraye Esquire. Learned counsel on behalf of the defendant did not equally cross-examine claimant as stated supra. Claimant was subsequently discharged and the case adjourned with an order that parties should file their final written addresses. In accordance with the rules of this court, learned counsel on behalf of the claimant filed his final written address on the 29th of December 2021, and equally filed a letter adopting same, which letter was deemed adopted on the 17th of May 2022. Learned counsel therein formulated 3 issues, which has been, and the argument in support of same, have been reduced into the body of this judgment. So I'll go straight to the decision of the court. I have carefully examined all the processes filed by the claimant as well as documents tendered. It is in my considered view that the vet issue begging for the court's intervention and determination is whether or not the claimant has proven his case to be entitled to the relief sought. Let me start by addressing the way and manner learned counsel for the claimant Inyeke Kwendu CJ Esquire cited some authorities in his final written address. Learned counsel, while arguing issue 2 on page 7 of his final written address, cited some cases thus, quote, Ayola and Pedro, Supra, Khan versus Harrison, Supra, Afewai Microfinance Bank Limited versus Sequos Nigeria Limited, Supra, Amechi and INEC, Supra, Ladotun and Oyewumi, Supra, and Mobile Producing Nigeria Unlimited versus Udo, Supra. Learned counsel also at page 8 of the address cited the case thus, Bilante International Limited versus NDIC, Supra. Let me point out that learned counsel had no prior to that cited these judicial authorities in the address to warrant the use of the word Supra. Learned counsel failed to include the year the authority was reported or the particular law report that reported same. He just merely cited the cases without clarity and quoted from the same decision. Learned counsel owes it a duty to this court to cite authorities correctly if he wants the court to consider same. Where the authorities are reported, as in this instance, the name of the law report, the year, volume, and the page must be cited by counsel. See the following cases. Ugon Gadi and Federal Republic of Nigeria citation captured, the case of Chidoke and another versus First City Finance Limited citation captured. To dump authorities on the court without clear reference that would not be accepted by this court. The said authorities are thus discountenanced. Before going into the merit of this case, it is important to know that the defendant neither filed statement of defense nor lead any evidence, and it has equally failed to cross-examine the claimant or called any witness, and also did not object to the documents tendered by the claimant despite being represented by defense counsel. The law is settled that a defendant who failed to file a statement of defense is entitled to a hearing before the court, even though he cannot lead evidence. The only legal effect in that circumstance is that the defendant is deemed to have forfeited his right to first address the court. However, he can, for example, rely on a point of law arising from the statement of claim without the necessity of filing pleading and adducing evidence. He may rest on the claimant case and simply wish to address the court on the issues raised in the claimant's case. Say the case of Maje Kodumi and others as Ogunsheye, citation captured, and the case of Main Street Bank and Yao, citation equally captured. However, the defendant in this case did not equally exercise its right to address on any point of law raised in the claimant's claims, despite being aware of the order of the court for parties to file their final written addresses. In fact, Nubarai Esquire indicated to the court that the defendant may file a final written address in this case, the option he again failed to comply with. This tried law that the effect of a failure of a defendant to file pleadings is that the assertions of the claimant in his pleadings stand unchallenged and are deemed admitted and established. See the following cases: Bauchi State Government versus Gumau and another citation captured, the case of Omali and Federal Ministry of Lands, Housing and Urban Development and Orders, citation captured, the case of Ulumeze and Onegbedan, citation captured, and the case of Consolidated Resources Limited and Abufa Ventures Nigeria Limited, citation captured. However, this court is mindful of the nature of the claimant's reliefs as evinced by his general form of complaint, e.d.s. declaratory reliefs. Declaratory actions fall within this exception to the rule of admission, as the claimant must always rely on the strength of his own case and not on the weakness of the defendant or default of the defendant to file a defense. In the case of Al-Hassan and another versus Shaku, citation captured, the Supreme Court per Rhodes Viables GSC retired, stated succinctly thus, I quote, Sections 20 and 21 of the Evidence Act provides for admission. Admissions in pleadings are a waiver of all controversy on the facts the pleader admits. However, the exception of this is where the plaintiff or claimant or petitioner seeks declaratory reliefs. It then becomes a different kettle of fish. The law is settled that declaratory leaves cannot succeed even on an admission by the opposing side. The reason is that a declaratory action is discretionary in nature. It is a species of civil action whose purpose is to seek an equitable relief in which the plaintiff prays the court in the exercise of its discretionary jurisdiction to promote or declare an existing state of affairs in law in its favor, or as may be discernible from the averments in the statement of claim or pleadings from the claimant. Hence, the onus of proof here lies on the petitioners. They must succeed on the strength of their own case and not on the weakness of the defense, except where the case for the defense supports the respondent's case, unquote. See also the case of Achi and another versus Chabo and other citation captured, case of Oyetola and Adeleke and other citation also provided. I'm equally mindful of the fact that the defendant in this case equally did not exercise its right to co-examine claimant when he testified on those, something which the learned counsel on behalf of claimant in his final written address relied on. It is the law that a party who, though has not filed or entered defense, still has a right to cross-examine the witness of the adversary. See the case of Keystone Bank Limited and Anko Enterprises Nigeria Limited citation captured. This is because a defendant by such cross-examination might simply want to create some doubt regarding the credibility of the evidence of the witness or authenticity of the documents tendered by the witness, if any. In line with the above position of the law, the defense counsel, Nubaharaye Esquire, was called upon to cross-examine the claimant on the 9th of December 2021, and he responded that he had no cross-examination for claimant. Such a party who was given an opportunity to be heard by way of cross-examination but failed to exercise same cannot equally be heard later alleging that it was not given fair hearing. See the case of Adamawa State Ministry of Lands and Survey and others versus Salisu and others citation captured. It is only when the defendant refuses to cross-examine the witness that such a party will be deemed to have accepted the testimony of the said witness. This is because cross-examination is a potent weapon or instrument in the hands of the party to challenge his opponent's case and seek to weaken it and or strengthen its case. It is the position of the law that unchallenged and uncontroverted evidence ought to be accepted by the trial court. More importantly, where the adversary or the party had every opportunity to cross-examine the witness of the opponent but fails to do so. See the cases of Gambo and Issa and another citation captured, the case of Naipos and Musa citation provided, the case of Gaji and others versus Paye citation also provided. And in that case, the decision of the court per Edoze GSC is paramount here. It is therefore without doubt the failure of the defendant to cross-examine the claimant, even when given the opportunity to exercise the right to operate as a tacit acceptance of the truth of the testimony of the claimant as contained in his written statement on oath, which is his oral testimony. Besides, an unchallenged and uncontroverted evidence is deemed to be good evidence, which the court can act on except where such is manifestly unreliable. See the cases of Musa and another versus Ibrahim, citation captured, the case of Ezochukwu and another versus Unwuka, citation provided, the case of Morigbe and Lawani, citation provided. Accordingly, this court will rely on claimant's testimony in proof of this case. So far, same is credible and reliable to ground the relief sought. Now to the cross of this suit. There's no doubt that the employment relationship between the parties in this case is that of master-servant relationship, wherein the master reserves the right to terminate the employment of his employee, provided he complies with the provision of the contract. See the case of Shuaibu and others versus MBC, PLC, Coca-Cola, citation captured. The case of CCG Nigeria Limited versus Bakari and another citation also captured. Claimant in this case averred that his employment has been terminated on the 10th of May 2019. The letter of termination is admitted and marked as Exhibit M1, and it is clear that the letter is dated May 10, 2019. Ordinarily, an employer is not bound to give reason for the termination of the employment of an employee. However, where an employer gives reason, he must prove such reason in order to justify the termination of the employment to the satisfaction of the court. Because we look at Exhibit M1, clearly shows that claimant's employment was terminated for services no longer required. The court in the case of Union Bank and Salahuddin citation captured held while relying on the case of NITEL PLC versus Aqua citation provided on termination for services no longer required does, and I quote, "The question that now agitates my mind is whether the words for services no longer required qualify as a reason as to require the appellant to establish by evidence. This scenario occurred in the case of NITEL PLC and Aqua citation captured where my Lord Sanusi JCA, as it then was said, the effect of the judicial decisions, some of which I cited above, which stated that an employer needs not give reason for termination simply means that the master employer needs not give a catalog of allegations or accusations of any wrongdoing or offense committed by the employee in terminating his appointment. In other words, even if the employee was never involved in any wrongdoing, misconduct, fraud, or any act that smacks of criminality, his employment can still be terminated. In my view, to say that the phrase your service is no longer required amounts to giving reason for the termination which requires the employer to justify is stretching the meaning too far, unquote. It is clear from the above authority that where termination is for services no longer required, it would not amount to a reason that the employer will be required to justify. In any case, it is clear from the relief sought in this case and the pleadings of the claimant as contained in the statement of fact that is not actually challenging the termination of his employment by the defendant. Rather, claimant grouses with the non-payment of his salaries and terminal benefit by the defendant since September 2018. There is no doubt, as reasoned above, that an employer in a master-servant employment reserves the right to terminate the employment, as I've stated earlier. However, it should be noted that the right given to an employer under a master-servant relationship does not include the right to deny an employee of his lawfully accrued earnings after the termination of employment. This is because it is a tried principle that an employee is entitled to be paid for work done in the course of his lawful engagement, except where he has not worked. See the cases of Springbank versus Babatunde citation captured, the case of CCB, Nigeria Limited versus Inwaco Supra. The claimant in this case is contending that the non-payment of his salaries and entitlements by the defendants in September 2018 except February 2019 is illegal, unlawful, abusive, and humiliating. Claimant viewed paragraphs 3 to 4 of his statement of fact averred that he has served meritoriously in the service of a defendant without being found wanting of any infractions before his employment was terminated on 10th of May 2019, and that he was dedicated to his job and carried out every task given to him at all material times. These facts were equally reiterated in paragraphs 4 and 5 of the statement on oath, which has already been admitted by claimant as his oral evidence in this case. Claimant equally stated that on the 13th of May 2019, in line with the directive and the letter of termination, when he arrived at the office to finalize the release of his salaries or entitlements, he was refused, and as a result of which he made frantic efforts to be paid, which yielded no results. These facts were equally reiterated in his statement on oath, which is his oral evidence. The evidence of the claimant as reason supra has not been challenged or controverted by the defendant, and therefore the court can rely on same as they are credible. It is apparent on Exhibit M1, termination letter, specifically at paragraph 3, that the defendant evinced and clearly expressed its intention to pay claimant his final entitlements, wherein he stated those, I quote, "Our payroll department is currently working out your final entitlements, and this will be communicated to you during your offboarding process," unquote. The defendant by this paragraph has raised the hope of the claimant to receiving his entitlement after terminating his employment, but failed to comply with it in flagrant disregard to the contract between the drawer and its express intention to pay him his entitlement. By the ILO Convention number 95, the Protection of Wages Convention 1949, ratified by Nigeria, the convention forbids the practice of deductions or withholding of employees' salary or terminal benefits. Specifically, Article 12, Sub 2 of this convention provides those, and I quote, Upon the termination of a contract of employment, a final settlement of all wages due shall be effected in accordance with national laws or regulations, collective agreements, or arbitration award, or in the absence of any applicable law, regulation, agreement, or award within a reasonable period of time having regard to the terms of a contract, unquote. It is obvious from this provision that the defendant ought to have paid the claimant his terminal benefit after compulsorily retiring him or after compulsorily terminating his employment within a reasonable time. Just a minute. Claimant's employment was terminated via Exhibit M1 since May 2019, which is more than 3 years now. If I may ask, has the defendant paid the claimant his entitlement within reasonable time after termination? The answer is definitely in the negative. From the above, it is not in doubt that the claimant, having worked for the defendant, is entitled to be paid, and the defendant do not have any power to withhold it, and is in law stopped from withholding his salaries and entitlements from him without any justification. An employee is entitled to his wages, and he cannot be denied same under any guise or excuse. Accordingly, Relief A succeeds. It is claimant's claim for salaries and entitlements from September 2018, except February 2019, claim 1 for salaries and entitlement from September 2018, except 2019. It is tried that monetary claims are in the realm of special damages and must be specifically pleaded and strictly proved. See the case of IG, Botosho and RCC citation capture, the case of HGR Limited versus BChem Limited citation captured. Specifically in the case of Adekule and UBA citation provided, the Court of Appeal per Samani JC, while relying on the dictum of Chukwumayene, GSC of blessed memory in the case of IHAM ABU HMB versus Kanyip, citation captured, held those as regard claim for salaries and other entitlements, and I quote, the law is that claims for salaries, allowances, bonuses, emoluments, and so on are in the nature of special damages, like in all claims for special damages. They need to be pleaded with particulars and evidence led thereon before they will be granted. He continued at page 20 to 21, paragraph 8 does. I must observe in regard to this matter that the respondent with regard to her pleadings has neither pleaded satisfactorily her special damages to with the salaries, allowances, and other benefits that is accruable to her as pronounced by the lower court in its judgment, nor have these items of special damages been specifically proved. Nonetheless, the law is tried that unless pleaded and strictly proved, the court is not obliged to make any awards in that regard for special damages. This aspect of the lower court's judgment should be set aside and are so hold. In the case cited above, the respondent, upon dismissal from her employment by the appellant, has sought for the following reliefs, among others. I quote again, payment of all arrears of salaries, allowances, and other benefits to which the plaintiff have been entitled from the 11th June 1995, being the date of her interdiction from duty, unto the determination of this suit, unquote. The claim of the, thus claim of the respondent in that case would appear to be in pari materia with the appellant's claim subject of this appeal. It is clear, therefore, that the appellant's claim for salaries, allowances, and other perquisites of his employment are in the nature of special damages, which needed to be pleaded and specifically proved, unquote. The claimant's relief B for an injunction compelling the defendant to pay the claimant his salaries and entitlement owed him since the month of September 2018, except February 2019, is in pari materia with the claim respondent's claim in the case cited supra. And as such, must be specifically pleaded and strictly proved. Equally, by the provisions of Order 3, Rule 12 of the Rules of this Court 2017, claimant is supposed to plead how much is his salary and the total amount being claimed or owed. It is the claimant's assertion, paragraph 14 of the Statement of Fact, that he was not paid his salary since September 2018, except 2019, February, which this court has held that he cannot be denied in Relief A above. However, claimant did not plead a particular amount he is entitled to as salary in a month or what is specifically claiming as entitlements the period under consideration. Although Exhibit M2 dated 1st March 2018 with subjects, quote and unquote, salaries upgrade, step increase, and percentage increase on the basic salary, shows that the claimant is entitled to 215,260 naira per month. It is a tried principle of our law that evidence led on facts not pleaded goes to no issue. In the absence of any specific averment as to the exact amount claimant is entitled to, the court cannot rely on Exhibit M2 to award claimant the payment of his salaries and entitlements owed him since the month of September 2018. Claimant has not satisfactorily pleaded his special damages to meet his salaries and entitlements. Accordingly, Relief B fails. Regarding Relief C, the claimant is urging the court to restrain the defendant, its servants, agents, previous officers, authorities, bodies, or any person from interfering, distributing, or howsoever tampering with his appointment until the backlog of his salaries and entitlement being owed him since September 2018 is paid to him. Although this court has, by Relief A above, declared that the refusal of the defendant to pay claimant his salaries and entitlement is unlawful, abusive, and humiliating, it will not, however, give the court the power to fetter with the right of the defendant to terminate the employment of the claimant. This is because the law is right that the court cannot impose a willing employee on an unwilling employer in a master-servant employment relationship, as in this case. See the case of Oshisonya and Afribank Nigeria PLC citation captured, Tezaco Nigeria PLC and Alfred G. Adebite Kane, the citation provided, and the case of Olariwaju and Afribank Nigeria PLC citation captured. It is in consequence that I hold that the claimant's employment remains terminated, notwithstanding that he has not been paid his arrears of salaries. Thus, Relief C also fails. It is Relief D of the claimant that failure of the defendant to pay him his salaries and entitlements since September 2018, except February 2019, have caused the claimant a lot of suffering, hardship, and humiliation. I felt supra that for declaratory release to succeed, claimant must rely on the strength of his case and not on the weakness of the defendant's case. Now, the question that comes to my mind is that, has the claimant proven that the defendant's action caused him suffering, hardship, and humiliation? The testimony of the claimant in paragraphs 12 to 14 of the statement on oath alone is not sufficient to prove and sustain the grant of this relief. Although the defendants did not file any defense or challenge the claimant's evidence, I'm mindful of the fact that the claimant has equally failed to prove or show to the court the negative or resultant effect of the defendant's action on him by proving that the failure has caused him suffering and hardship. Consequently, I find that Relief D also fails. Claimant, by his Relief E, is seeking for 150 million naira as general damages. The law is right that where breach is established, general damages will follow without need to specifically plead it. See the cases of SPDC Limited versus Zimbabwe is a citation capture, the case of Felix George and Company Limited versus Afinotone and others citation captured. General damages are these losses that follow naturally from the adversary and is generally presumed by law as it need not be pleaded. General damages are awarded by the court to assuage the injury caused by an act of the adversary. So the case of GTB versus Diodone citation captured. Having held that the defendant's act of withholding the claimant's salaries and entitlement is unlawful, abusive, is not entitled to damages. An employee, as reason supra, is entitled to his wages. To withhold it is likened to withholding the very life of that employee or sniffing life out of him. This court held in the case of Peter Demenge Kumba versus Dar Communications PLC in an unreported suit number NICN/ABJ/25/2020, a judgment delivered on 3rd March 2021 does, and I quote, "There is equally no agreement to arbitral award placed before this court by the defendant granting it the liberty to withhold claimants' terminal benefits since February 2018. This is accrued and earned terminal benefit for an employee who has served his employer for 14 years, is out of job, and has no other means of livelihood. His terminal benefits, gratuity, and pension are his life wire upon which he can live and take care of his family. 2 or upward of 3 years withholding of claimant's terminal benefit is the most unreasonable and unconscionable. It is against the ILO Convention on Payment of Wages, and thus claimant should be entitled to general damages, which is above the payment of the money he would have earned, unquote. It is obvious by the decision of this court in the Dominguez case supra and a host of other cases on this subject that it is the most oppressive and unconscionable for an employer to withhold an employee's terminal benefits and entitlements. It is consequent upon this that I find that claimant is entitled to damages. This court is empowered by the provisions of Section 19, paragraph D, of the National Industrial Code Act 2006 to award compensatory damages in deserving cases of breach in any case that is within the jurisdiction of this court, as in this instant. By Exhibit M2 titled, quote, salary upgrade step increase and 8% increase on basic salary, unquote, the defendant put the claimant's salary at 215,260 naira per month. It is on this premise that I award to the claimant 3 months' salary in the sum of 645,780 naira only as damages for the defendant's unlawful act of withholding claimant salaries and entitlements up to date. I so award. On the claim for 1 million naira as legal or professional fees, there is no doubt that a claim for solicitor's fee is equally a claim for cost of action. Position of the law is that cost follows event, and the successful party should not be denied of his cost unless for good reason. So the case of Bono Nigeria Limited and another citation captured. It is settled law that award of cost, including cost of litigation, is always at the discretion of the court, with discretion must be exercised with judicial and judicious, must be exercised judicially and judiciously once empowered by its rules. This was the position of the Apex Court on award of costs in the case of Mekuye and Emirates Airlines citation capture. By the provision of all the 5 rules 1 and 5 of the rules of this court, this court is empowered to exercise its discretion. Is empowered to exercise its discretion in the award of costs and to ensure that a successful party is indemnified for the expenses to which the party has unnecessarily put in the proceeding. Claimant in this case has succeeded in some parts of his claim and was able to show that the defendant has willfully refused to pay him his earned salaries. The circumstance in this case is one deserving of an award of costs. Claimant in this case equally relied on Exhibit M3, which is the receipt of payment of solicitor's fee in the sum of 250,000 naira. In the exercise of my discretion and considering the number of sittings in this case wherein claimant and his counsel were present and the number of processes filed by claimant in this case, I award the claimant the sum of 100,000 naira as cost in this suit. I so find and hold. In summary, the claimant's claims succeed in part. I thus make the following declarations and reliefs and orders. 1, that the non-payment of the claimant's salaries and entitlements is legal, unlawful, unconscionable, and should be paid. 2, reliefs B, C, and D fail. 3, that the claimant is entitled to the sum of 645,780 naira only as general damages. 4, that the claimant is entitled to the sum of 100,000 naira as cost. Judgment is entered accordingly. So a copy of the judgment will be forwarded to parties in Lokoja. Is there any other Lokoja matter? Court registrar. Which matter? Which matter?
For readoption.
Eh?
The one for readoption.
Readoption. What's the suit number? Check it on the floor. What's the suit number?
02, Your Lordship.
What's the name of the parties? Eh? I can't hear you.
Ojabulu.
Ojabulu.
Yes, it's over.
And who? And who?
Ajokuta Steel Company Limited.
Ajaokuta Steel Company.
Yes, Your Lordship.
When am I sitting in Lokoja again? 25th and 26th. So fix it for one of, because I don't think they are aware. So the case file is not here.
Your Lordship, we are giving a letter from the National Industrial Court. Both counsels are in court, Your Lordship. It's for readoption.
Okay, then wait, let them get the file then.
Okay, Your Lordship.
Your Lordship. Your Lordship.
Yes.
We are very grateful for your judgment. And I know that if the lead counsel was still alive, we would be very happy for your kind judgment. And we also pray that the good Lord will continually give you wisdom to dispense justice. Thank you very much.
I can't see your face. Nene Counsel, I can't see your face. Oh, okay. Very well. So we are waiting for the other case file. And call the case. Lokoja Court Registrar. Call the case. Who is it? Parties absent. Appearances.
May you please, Honorable Court, I am C.M. Uche. Most humbly, Your Lordship, I make appearance for the claimant in this case.
Any other appearance?
Yes, my lord. May it please Your Lordship, I am C.N. Umesiobu, and I am holding the brief of E.A. Obu.
Emesiogu. Is it G-W-O?
U-M-E-S-I. O-B-U, my lord. And I'm holding the brief of E.A. Osayomi. And our humble appearance is for the defender, the first and second defender.
Your Lordship, the matter is slated for readoption this morning, Your Lordship. Counsels have filed their respective written addresses. And we are ready.
Go ahead.
Your Lordship, I think it will start with the defendant because the defendant filed first.
Okay, Mr. Emesiogu.
My lord, before this honorable court is the defendant's final written address, dated 29th day of November.
When was it filed?
It was filed on the 2nd of December, 2021. My lord, 4 issues were formulated and argument canvassed. My lord, upon the receipt of the claimant's final address, we equally filed a reply on point of law, dated the 2nd day of January, 2022.
And filed
on the 4th of January, 2022. We humbly seek the leave of the court to adopt both our final written address and reply on point of law, and urge the honorable court to enter judgment in favor of the defendant and dismiss the claimant case. I'm most grateful, Your Lordship.
Very well. Go ahead, Mr. Uchenwere.
Your Lordship. Your Lordship, we were in receipt of the defendant's final written address filed on the 2nd of December 2021. On which we filed our written address dated the 20th of December 2021, Your Lordship.
And was filed when?
Sorry, Your Lordship. It was dated the 19th. We apologize. It was dated the 19th of December 2021, but filed on
filed on 20th of.
Yes, on 20th December.
Very
Dated
well.
December, but filed on 20th December.
Very well.
We are also in receipt of the defendant's reply on points of law, filed on the 4th of January,
Very
2022.
well.
We urge this honorable court to grant our release as stated in our complaint. Your Lordship.
Very well. Where is my diary? Case adjourned to 20th of October for judgment.
Please.
Very well. Is that all for Lokoja? Very well, I rise.